Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about jurisdiction of the National Industrial Court in Maritime Labor claims. A review of the Court of Appeal decision in the Mount Sam Purpose 5 Amarjit Singh Bains. On the 5th of March 2021, the Court of Appeal in Nigeria Lagos Division delivered a landmark judgment in the case of the MT Sam Purpose or ex-MT Tapti and Anwar V. Amarjit Singh Bains and 6 ORS or Minister Sam Purpose versus Amarjit Singh Bains. The first is the appeal arose from the ruling of the Federal High Court or FHC. Lagos Division delivered on the 22nd May of 2020. Number 2, in resolving the primary issue before the Court of Appeal, that is, which court between the Federal High Court or FHC and the National Industrial Court or NIC has exclusive jurisdiction over maritime labor claims. The Court of Appeal relied on the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended. Constitution, the Admiralty Jurisdiction Act or ATA, the Merchant Shipping Act or MSA, the Labor Act and judicial precedents to hold that the NIC is the court vested with exclusive jurisdiction to entertain maritime labor claims bordering on the wages of crew members and or seamen. This decision has generated a lot of the controversy and heated debates among the labor and maritime practitioners and had brought to the front burner to the need for a re-examination of the jurisdictional scope of the above-named courts in the light of constitutional provisions, particularly as it relates to maritime labor claims. Before delving into the facts of the Minister Sam Purpose versus Amarjit Singh Bains and a review of the judgment, it is important to briefly discuss jurisdiction in the maritime labor claims. And then is jurisdiction in maritime labor claims. The relevant laws here are the Constitution, the Admiralty Jurisdiction Act, and the Merchant of the Shipping Act. Section 2 of the AGA defines maritime claims to include a references to a proprietary maritime claim or a general maritime claim. This means that maritime claims are broadly classified into two, and the first is proprietary maritime claims and a general maritime claims, and fourth is proprietary maritime claims are claims which directly affect the rest or the subject matter. They include claims relating to the A is the possession of a ship, and the B is the title to the ownership of the ship or of a share in the ship, and the C is mortgage of a ship or of any share therein. The D is mortgage of a ship's freight. The E, the possessions, ownership, operation, or earning of a ship between co-owners of ship. The F is satisfaction or enforcement of a judgment given by the court of any court. It is including a court of foreign country against a ship or another property in an admiralty proceeding in RAM. The G is interest in respect of any claim above mentioned. And Section 2 or 3rd of the Act describe the claims which fall under the general maritime claims. The claim relevant to this article is contained in the Section 2 or 3R, which states those A. Reference in this Act to a general maritime claim is a reference are a claim by master or a member of the crew or of a ship for the wages or the first an amount that a person as employer is under an obligation to pay a person as employee, whether the obligations arose out of the contract of the employment or by the operation of law, including by operation of the law of a foreign country. General maritime claims, unlike proprietary maritime claims, do not directly affect the rest or the subject matter, but arise out of the operation of the rest or any agreement relating to or connected with the rest. Furthermore, there are certain claims which is attached to the ship or rest, even where the ownership changes. These claims are known as liens. A maritime lien attaches to the ship or rest. Section 503 of the Fact provided that a maritime lien means a lien for a salvage or a b. damages done by a ship, or c. wages of the master of the member of the crew of the ships, or d. the master's disbursements. And the fifth, once there is a claim for an enforcement of a maritime lien, such gives rise to an action in a rem against the ships. An action in rem is an action that can lie against the ship, cargo, or freight. Before the recent decision of the Court of or Appeal, maritime claims were generally under the exclusive jurisdiction of the FFSC as provided by the Constitution, and such claims are enforceable by an admiralty action in rem on in personam. 7 Section 251 of the Constitution provides as follows. The verse is notwithstanding anything to the contrary contained in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly. The Federal High Court shall have exercise jurisdiction to the exclusion of any of other court in civil causes and matters. The G. Any admiralty jurisdiction, including a shipping and navigation on the River Niger or River Benue, and their influence on such other inland waterway as may be designated by any enactment to be an international waterway, all federal ports, and including the Constitution and powers of the ports authorities for federal ports. So thank you for watching, and don't forget to like, comment, and subscribe.